Did you know that the makers of our constitution made right to property as a fundamental right? This right was enshrined under Article 19(1)(f) and Article 31 of the Constitution of India. And ultimately, you also need to know what is the meaning of a fundamental right, what is the meaning of a constitutional right, and how it matters in reference to land acquisition. Because when it is a fundamental right, it cannot be taken away. If you have a property, you have a fundamental right to hold the property. But for the reason of national growth, it is always required that a land is acquired, maybe for making the roadways, maybe for making the railways, or for port, or for making a dam. These are all the circumstances where government genuinely needed the land. But citing the fundamental right, the property owners could obstruct the acquisition process. And that is the reason why in 1978, the 44th Amendment to the Constitution of India was brought into force. This toned down the right, that is fundamental right, was relegated to constitutional right under Article 300A. Now, this is a constitutional right definitely, but the safeguards are lowered. And under the provisions of acts, for example, like earlier Land Acquisition Act and now LAR Act, the government is empowered to take the possession of your land. Now, let us talk about the provisions of LAR Act. LAR Act was brought into force in year 2013. Prior thereto, there was a colonial law, and that law was known as land acquisition. And this law was generally seen to be a very forceful way of evicting the rightful possessors of the land. And therefore, there was long pending dissent against this law. Now, government wanted to make it a participatory process. Acquiring the land, say for example, for making a port or a dam, it's actually a public purpose. China is making great growth by way of making these infrastructure projects a reality. And when it comes to India, you know the story of bullet train. It took almost 10 years from the conceptual stage to the construction of the bullet train, and still it is not functional. So we talk about the process. We also talk about the various ways in which you can get the compensation. The law under Land Acquisition, Rehabilitation and Resettlement Act, also known as LAR Act, provides very many safeguards. When there are projects which is affecting huge amount of people, there are two things which are mandatorily required to be done. Number one is social impact assessment, and if it is passing through environmentally sensitive area, the environmental impact assessment is also a mandatory prerequisite. Generally, the landowners are not concerned about this procedural safeguard. Landowners are concerned about how much compensation shall I get, and therefore it is important to understand that compensation is not an award. Compensation is calculated at a market value by a factor of multiplier. Suppose if you are holding a land in a rural area, your land will be acquired at twice the market value of the land. That is a multiplier of 2. Whereas when the urban land is there is a multiplier of 1. This will determine the market value in the form of compensation. Now this compensation amount, generally the land is not going to be barren or unoccupied. There will be trees onto the land, there will be standing crops, or there will be building onto the land. So these are called the assets. This asset valuation is added to the amount of compensation. When this amount of compensation plus asset is determined, there is also another aspect that is called forceful eviction compensation. So that is twice the amount of the total compensation plus asset value, and that will ultimately increase the valuation that you are going to get as a final award. But many a times there are ways in which the government tries to lower this amount, and that is by way of lowering the market value, or maybe categorizing your land which is otherwise a rural land into an urban land, or there are many other ways in which you are likely to get a lower compensation. If you are aggrieved by the amount that is going to be given to you, you can always go to the higher authority. That is called an internal arbitration mechanism. And this arbitration mechanism will be known as a reference. So once the award is passed, if you are aggrieved, if you are not happy, you can go to the reference court. And this reference court will determine the market value. What are the factors? You can show that, see, this is the adjoining piece of land. The market value of the adjoining piece of land was determined to be more than my land. There is just distance of, say for example, 200 meters. This is not that distance where the arbitrary rise or the drop in the market value of a land will be there. So that authority under reference will determine the genuineness of your claim, or as the case may be, the claim of the competent authority who acquired the land. Now, if you are not satisfied even with the reference court passing the order, you can go to the district court under section 34 of the arbitration. This remedy provides an effective outlet for ventilating your grievances, and if you are not happy with this award, then ultimately you can go to the High Court. The purpose of this entire appellate hierarchy is that if at any stage you have been meted with a treatment of forceful eviction without appropriate compensation, the machinery of law will be put into motion to grant you an adequate amount of compensation. Mind well, there is one additional provision which has more than a doubling effect, and that is the interest component. If the compensation is not paid to you in a timely manner, then for each year that is lapsed, you are entitled to get 12% per annum for the period that is gone from the date of acquisition to the grant of the actual amount into your bank account. And therefore, you should always be vigilant about your rights. Many a times, it is not in your hands that your land is not acquired. It is needed for a national highway or maybe for a railway, and you have to give the possession of the land to the acquiring authority, but you are not helpless. You can always claim right amount of compensation if you go to the right legal experts, and therefore choose your lawyers for land acquisition process wisely.